It is March 23rd, 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today I have some of the most intense and unbelievable courtroom moments we've seen lately. We're starting with a high-stakes HOA war over property easements and firearms in Thurston County. Then we'll see a case where a heartbroken mother is forced to evict her own adult son, and Judge McNally is forced to do what he does best. Then, a McNally finale you have got to see to believe. A defendant caught in a blatant lie on Zoom while trying to outsmart the judge. It's a wild ride today, ladies and gentlemen, so buckle up, get some refreshments, grab a drink. It all starts right now.
Let's see, we've got here in the courtroom, Sarbury, is that right? Okay, so we'll go Wilbur Sarbury and Neil Weatherhead.
Sauerbry,
I'm sorry, that all kinds of wrong. All right, so what I'm gonna do before I turn it over to you folks is I want to go over a couple of things first. And first things first is, so there's been allegations of unlawful harassment by Mr. Weatherhead against Mr. Sarbury. Sarbury? I got it wrong. Sarbury. Sauerbray. Sauerbray. Last time I'll get it wrong. Sauerbray. All right. What I like to start these hearings with is sort of explaining that the words harassment and stalking, as you all may have kind of witnessed, there's some common understandings of what this means, what it means to be harassed, what it means to be stalked, that people use in everyday parlance. And that is all often very different from the legal definition of unlawful harassment and unlawful stalking. So what I like to do to start these hearings is go over the legal definition of unlawful harassment, because when I hear testimony and I ask questions, and when I go through the exhibits and what's been filed, which I've gone through everything from both sides, is what I'm looking for is whether or not the petitioner, so Mr. Weatherhead in this case, has proved more likely than not that there has been unlawful harassment, meaning that all of these elements, there's 6 elements, that every one of them has been met. So I'm going to go over those elements now because I want folks to understand that when I'm listening to your testimony, when I'm asking questions, these are the 6 things that I'm looking for. So unlawful harassment is, number 1, a knowing and willful course of conduct. Number 2, directed at a specific person. Number 3, without a lawful or legitimate purpose. Number 4, that appears designed to alarm, annoy, or harass the petitioner. Number 5, that would cause a reasonable person to suffer substantial emotional distress. And 6, and that actually does cause the petitioner to suffer substantial emotional distress. So those are the 6 elements, and those are things I'm going to keep coming back to. There's a couple of these that I like to go into a little bit more detail because that's where a lot of cases tend to get sort of caught in the weeds. The first is the first element, knowing and willful course of conduct. Course of conduct means there's been a pattern of behavior evidencing continuity of purpose. So it's not one single incident. In very limited circumstances form the basis of anti-harassment. What we are generally looking for is an ongoing pattern of behavior that persists despite someone being told to stop. So that's what we're looking for. The next one is directed at a specific person. I think you all are sort of witnessed that a lot of times petitioners and respondents will talk about things being done to other people, aren't parties to the petition. And again, that's relevant only if other people are being used to contact someone who is being protected or something of that nature. So we're looking at, and this is, I think, particular in this case too, that's why I raise it, is so we're looking at harassment directed at a specific person. Number 3, without lawful or legitimate purpose. Again, this is something that I want to focus on for this particular case. Some things we look at in whether or not the contact was lawful or legitimate is whether someone is unreasonably interfering with the petitioner's privacy or creating an intimidating, hostile, or offensive living environment for the petitioner. And I raise this here because this is not a forum for resolving land use disputes. And so, Mr. Weatherhead, one thing that I'll be looking for from you in particular is the difference between harassment on your property versus a dispute over whether or not representatives of the HOA are able to come onto certain parts of the property, whether there is the existence of particular easements, what the rules are for those easements, because the contact needs to be without a legitimate purpose. And so one thing we don't use the anti-harassment or docket to do is resolve land use disputes. And this is particularly true when we have issues between neighbors who are disputing property rights and who can go where and easements and things of that nature. That gets resolved through property type actions over in Superior Court. I know that's not the only much. That's part of the question that I've got for you, just so you know. So again, these are the things that we look for in unlawful harassment. So I'll back these definitions. I'll be going back to these elements because each one of these needs to be shown as more likely than not in order for an order to issue. So that's the legal stuff that I like to get out of the way early. A couple of housekeeping things. These hearings can get pretty heated. I find it's get even more heated, particularly when if someone is on Zoom, because then you're not really face to face, and sometimes it's a bit easy to get caught up saying. Direct all comments to me, to the court. Don't address each other. And all comments come to me. If folks start talking to each other, that's when I start cutting people off. So address everything to me, and also know that you'll get your turn. Again, you've seen at least one hearing already. I do try to let people go back and forth a bit, so as allegations are raised, so I can respond to that, things of that nature. So I do that in part so that people know if you start hearing things that you don't like, just recognize, we're not going to go forever, but you will have a chance to respond. So keep that in mind as well. Last thing before I start taking testimony is the protection order statute contemplates that decisions are made primarily based on the sworn declarations and what's been provided in the court file. So I've read everything. I've read the petition. I've read everyone's exhibits. Before I take testimony, I'm gonna go over my review of the record, just so everyone are able to see where I'm coming from, and you can kind of go from there. And then my approach to taking testimony is not to have somebody essentially give a speech about their position. It's conversational. I ask questions that help me get to an answer. Obviously, if you have stuff you'd like to say, you're welcome to, but it's really an opportunity for me to ask questions and learn a little about what's going on here, and to align what I think is going on here with what's required under the statute. So with all that said, I'll take testimony from Mr. Weatherhead, Mr. Sauerbry, and then we'll go from there. Before I do that, what I want to do is go over the timeline as I've reviewed it from the docket. And that way, again, both of you can see where I'm coming from. And you can correct me if I get it wrong or fill in the gaps. So Mr. Weatherhead is arguing unlawful harassment based on roughly the following timeline. In my understanding, again, Mr. Weatherhead owns property that is within this homeowners association. And on September 20th, I think is the earliest date that I've got, there's a allegation that Mr. Sauerbry came onto Mr. Weatherhead's property. Mr. Weatherhead texted Mr. Sauerbry saying you're trespassing. And Mr. Sauerbry replied essentially that it seems like a disagreement over where, again, the property line is, where the HOA can go for HOA business. There's some allegations from the HOA. It sounds like that Mr. Weatherhead was in possession of HOA property and equipment, and that Mr. Sauerbry, as a representative of the HOA, was there on HOA business. So that's September 20th. November 6th, again, there's allegation from Mr. Weatherhead that Mr. Sauerbry is on his property and spray painting. In his response, Mr. Sauerbry indicates that there's an ongoing dispute regarding the existence of an easement at the end of Starflower Lane, or existence or scope of an easement at the end of Starflower Lane, and that he was there measuring it way to identify the easement. Mr. Sauerbry indicates Mr. Weatherhead may be violating some CCRs with respect to that easement as part of the HOA. So that's November 6th. February 19th, Mr. Sauerbry sends Mr. Weatherhead an email regarding it on February 25th to address some alleged CCR violations. Mr. Weatherhead requests more time. That request is denied. Then on that day, February 25th, Mr. Sauerbry, as I believe two of the witnesses here, Ted Weiss and Ariel McClendon, go on to, I guess at least what's alleged to be Mr. Weatherhead's property. And there was a confrontation there between those three folks from the HOA. And not Mr. Weatherhead, but Mr. Weatherhead's fiance, Lindsay Silling, and his father, Neil Weatherhead Sr., I suppose. And the HOA folks were told to leave. It seems like there was a bit of a confrontation. This is where Mr. Weatherhead alleges that Mr. Sauerbry brandished a weapon and put his father and fiance in fear. Mr. Sauerbry denies that and shed a little bit more light on the confrontation, essentially saying that they being the HOA representatives, announced to Lindsay and Neil Sr. That they were there on HOA business. There was an argument. They were left when they were asked to. There was some difficulty in turning around, but that they did try to leave, and that I think Miss indicated that she felt herself in that situation. And that being the last instance that I've got noticed. So that's where I'm at. And so with that in mind, that's the roadmap here. I'll now swear in the parties and go from there. So, Mr. Weatherhead, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the whole truth?
Your Honor.
Go ahead.
Your Honor, I'm seeking anti-harassment protection order on Mr. Sauerbry and his proxies based on the pattern of unwanted entry onto my property that you've already stated, the refusal to leave when asked to do so, and as you already mentioned, the conduct that I reasonably perceived to be intimidation, including the presence of the firearm by Mr. Sauerbry and the statement that he was there for intimidation. I want to be clear, I'm not asking the court to resolve the HOA dispute regarding the property and road maintenance. I'm simply here to seek this anti-harassment order as my counsel prepares for a civil case to be heard by Superior Court. And the fact that Mr. Sauerberry continues to enter my property, elicit towing companies to tow my property and my friends' properties, and make slanderous claims, and both to me and online within our community. So I prepared the whole timeline. You kind of touched on each one, so I'll spare the court time in going back over those. As you can see, there's been an ongoing escalation each time I've requested documentation from Mr. Sauerbrei that the easements were in fact under the rules that he was trying to enforce, which the rules, to my knowledge, have been made since Mr. Sauerberry became president. For past context, I was part of the HOA as the treasurer prior to this, and I stepped down due to the slanderous claims that Mr. Sauerberry and his wife were making on me and the road maintenance. So I decided to step down and have been pursued in this harassment and slander ever since. This all started actually on September 10th when I approached Mr. Sauerbrei about, as the new president, about ongoing issues with people trespassing on my property, both from Cindy Smith, an adjoining property owner, and Ted Wise, who's also here. It was the 10 days later that he tried to flip the table, that I was under, or I was storing vehicles against the rules that he stated as on the turnaround that Cindy Smith had erected, but not against county drawings that were drawn up. She, instead of doing it both on my property and her property, decided to do it all mine. So that I've been trying to work with the county to figure out if that's allowed. And as far as I'm understanding, she was not supposed to do it all on my property. But back to the harassment at hand. On February 25th, I decided to make this anti-harassment suit because it was clear that it was escalating to a point where he was intimidating my family, and with a weapon at this point, it made us fear for our safety at this time as we prepare for court in the Superior Court.
So, Mr. Weatherhead, what's the Superior Court action? Is that what type of action is that?
Yes, Your Honor. It's my case is that ever since I stepped down from the HOA, I'm being selectively enforced upon. The rules have changed in their favor and against mine without the proper voting authority that it's supposed to. In Chapter 8 of our CCNRs, it's required that over 50%, 67% actually must vote pro for any changes to the CCNRs.
Okay, so so it's a civil lawsuit over issues relating to like HOA operations and things of that nature.
Yes, Your Honor, because there's at least 10 other violations that aren't being pursued. Only mine are.
And then, so your petition names your children, or at least three minors. I believe two of your fiance's last name, one is yours. But it does not name your fiance or your father. And so the most concerning allegation you make obviously concerns an incident with brandishing firearms. And so I'm not saying that you weren't there sort of defeats the petition. But my question is, you know, how does the brandishing the firearm, is that a pattern of behavior that you're saying happened in that interaction, or was that something you heard from your fiance and your father happened, and those kind of last straw situations for you? Talk to me a little bit more about that, since those two folks, your fiance and your father, are named in the petition, but it sounds like action against them is sort of the basis of what brought you to. So talk to me a little bit about that.
Yeah, sure, Honor. That might have been an oversight on me. I intended to include them in the petition as well. I thought there were separate sections for minors and adults. But Mr. Sowerbury brandishing a weapon is not uncommon. He has it on his hip at all times. In this instant, he was touching it, from what I was told, excessively, and made the statement that he was there for intimidation.
All right.
What
So
was the other question?
Okay. So, and is Miss Silling with you? Is she able to talk, or your father?
She's not, Your Honor. She was available at the previous court date, but has to work today, unfortunately.
So her allegations, though, because I believe the petition it references, I think it just has brandishing firearm is the language. So specifically, I was curious kind of specifically what the allegations were. So correct me if I'm wrong. It sounds like what you're saying is he had a firearm holstered, but was touching it excessively. Is that accurate?
Yes, Your Honor.
Do you have any experience where something like that had happened before?
Yes, Your Honor. He's had it and kind of flaunted his firearm, and a lot of our HOA meetings, we meet up to do road cleaning or something, and he's in possession of it and tries to express that intimidation kind of factor. But.
All right. And then you also indicated that in the petition, let's see, I guess I'll read it to you. Find the right spot. Okay, so yeah, in your petition, you indicate that you allege that Mr. Sowerbury is antagonizing you and your family while making it known he's carrying a pistol, and I think you essentially just said something to that effect here too. Can you tell me a little bit more about what that means?
Yes, Your Honor. Touching it and just drawing attention to it was the primary concern, and then his verbal expression that he's there for intimidation. Okay.
And did your fiance, did she say that was, do you recall like the words used? I mean, was that it? That.
Yes, Your Honor, that's what she said.
Okay.
She had recorded it, and it's kind of muffled when he says that, but so that's why I didn't include that recording in discovery.
And last question before you'll have a chance again, but before I turn it over to Mr. Sowerbury, so with respect to the kind of the allegations of trespassing, are you saying that Mr. Sowerbury is coming onto your property where it's undisputed that it's your property and that he doesn't have a right to be there because of any kind of easement or any kind of HOA business? Bless you. Or are you saying that, are you is it the case that these are issues that are being disputed, and you feel you're correct, and that and so this is not an issue that can otherwise be resolved? He's just coming onto your property.
Yes, Your Honor. So September 10th, when I initially contacted him about himself and others trespassing, and then again on the 25th of September, and where I show that I expressly showed him the map where the road ends. Another exhibit, I can't recall off the top of my head, and I don't have it pulled up, shows that map and where my cameras are located, but I have pictures of him crossing the cameras northerly of where the road ends, that he knowingly passed. So I guess a little bit more context. When I had these issues with the trespassers, I put a rope up across the road where the end of the road essentially is, not specifically because of I would have had to put a post in the middle of the roundabout if I did it specifically. But I put a rope up that said no trespassing, so people that didn't know if they were trespassing or not knew once they crossed that rope. It's a physical barrier. I also included in my pictures the other 5 instances where other lot owners have done a physical gate at the end of the roads in the middle of the intersection that is designated for the same kind of ingress-egress easements. So Mr. Sourbrae crossed that rope and continued northerly onto what would be considered my driveway at that point, but it's built to the standards of the road as well. Multiple times after I proved to him where it stopped.
All right. Okay. Thank you, Mr. Weatherhead. Again, well, I'll come back to you one way or another. Since it's your petition, you also get the last word. So it is coming back to you. But for now, I'd like to swear in Mr. Sourbrae. And before I do that too, there are instances in the statute where the court can hear from non-party witnesses if their testimony would be material, so important, and necessary to the decision. I don't know if Ms. McClendon or Mr. Weiss were intending on testifying today or not. It sounds like they were the other ones who were on the respondent side present for the issue on February 25th. And so I would be curious about anything they have to say on what they witnessed there, because that is sort of a bulk of the allegations come from that interaction. So I'll leave that in mind, and I might ask Mr. Sourbrae what his preferred preference is for today. But to start with, I'll hear from him directly. So if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes, I do.
Okay. And were you intending for Mr. Weiss and Ms. McClendon to testify?
I was, yes.
Okay. All right.
I guess I would put that kind of back to you, but my thought with having them is then it wouldn't be my word against somebody else's word, but there would be more people that were there at the incident as witnesses.
Yes, and that's the reason I would want to hear from them.
Yes.
Is if it is a allegation and denial, the more information I have, the better. And so yes, I mean I do find that their testimony would be material and necessary. So I'll hear from them if they're willing to testify. But I want to start with you. So you heard me go over that roadmap. You've also heard Mr. Weatherhead's arguments or allegations there. So I am particularly interested in hearing from you on, again, I understand it sounds like there's a lot of disputes going on around the HOA business and property lines and things of that nature. So certainly talk about that. And I know you've uploaded exhibits on that. But the allegations against you, I think is making it known that you've got a firearm. I think that's something that I want to know more about as well. So as you going through this, addressing those allegations as well, because frankly, that's something that's concerning. So if you want to respond to that too, I'd encourage you to address that part. But that said, you heard my roadmap. You heard what Mr. Weatherhead had to say. Go ahead.
Yes, Your Honor. So first, I would just like to say that I truly believe that all of this is related to HOA business. Even though all of the area of the HOA, the way that it is written up is so that the roads could be used by all HOA members for the convenience and enjoyment of all HOA members. That being said, myself, my family, we really don't go down any of the other roads for anything. Very rarely do we. So I have no reason to go down any of these other roads other than HOA business. With that said, I would also like to go to a very important part, as you stated, with my firearm. I do have a concealed carry permit, and I do carry almost from the time I wake up till I go back to bed, Your Honor. That being said, after I first moved here to the state, carrying open, not received very well by a lot of persons. So I don't do that anymore. I exclusively have my weapon concealed, and I don't touch it. I don't want people to know that I have it. I don't want to have it, but I do have it, and I do carry it. But I definitely want to make it known that I don't let other people know that I have it. Some of the things that Mr. Weatherhead brought up, that a part of his big concerns is that he's being isolated. He has sent some emails in. He hasn't followed exactly the rules on reporting violations. However, he has in his way, he has reported some of these violations. The board, we have taken a look at them, and other than one that I just revisited with him, definitely don't meet the criteria of a violation. There's one that he just spoke with me Friday, I believe it was Friday, but within the last few days, Your Honor. And the board, the HOA will need to go and check that one out. Again, I haven't been down there, so I don't even really remember this as being an issue, but it will be something that is checked out.
So that's a violation. Mr. Weatherhead has reported to the HOA that the HOAs may go out and investigate. Okay.
The other ones that he's pointed out, we have looked at, and there was one that he pointed out on me, and I addressed that and fixed it by planting trees. And the other violations that he's reported, we've deemed are not violations. They could potentially be. I could see why he reported them, but after investigation, they're not. He's alleging, another violation that he mentioned was one of his neighbors having visitors or something coming onto his property. I spoke with him about that, and he put up signs to mark. He has trails out there on his property, so he said he marked the trail better to keep people from going on to Mr. Weatherhead's property. And I haven't had any more reports of that happening.
Okay. Let me ask you to pause, because a question just came to mind that I don't want to forget about, and I think is relevant to what you're saying. Mr. Weatherhead, practically speaking here, so it sounds like you're continuing to engage with the HOA about what you feel are violations and things of that nature. Have you thought about, or can you talk a little bit about the practical limitations and challenges that if you were to get an order against Mr. Sauerbrei, being able to engage with the HOA if he's not allowed to contact you?
Yes, Your Honor. And at risk of going too far into what the rules of the HOA and you making a decision on that. Again, this all started with Mr. Sauerbrei. I'm addressing the issue of people trespassing on my property. We've tried signs and my road.
Well, I'm gonna come back to you about kind of the broader question, but that question specifically, are you saying you don't want him to contact you anymore?
Yes,
Because
Your Honor,
it sounds like the concern that I'm hearing is if he is in HOA leadership and you are engaging with the HOA and resolving some disputes, sounds like in a different court or through a lawsuit, that's not something that Mr. Sauerbrei would be able to engage with you on anymore.
Correct, Your Honor. Let me redirect back to your question. Before this, when I was on the HOA, many of the members had expressed interest in dissolving the HOA completely, as its sole purpose, as Mr. Sauerbrei, when he was previous president, had stated, was to maintain a portion of road that is now paved, and we no longer maintain that. So I started a petition, first I got verbal confirmation from at least 50% of the members in our community that they would like to dissolve the HOA. Unfortunately, we have to have 67% because it's dissolving the HOA. But part of that petition was to relieve Mr. Sauerbrei of his duties as the president. And we only need 50% votes for that. And I got that verbally, and it's out to vote right now as we speak. So as soon as those votes get returned, I plan to call a special meeting that relieves Mr. Sauerbrei from his duties as the president of the HOA.
Okay, thank you. I was just curious if that's something you thought about, and it sounds like you have. Okay, I wanted to address that before we got too much further. Okay, thank you for that, Mr. Weatherhead. Okay, back to you, Mr. Sauerbrei. I'm sorry I cut you off. You were talking about the issues with Mr. Weatherhead indicating other folks have been coming onto his property. If I could kind of direct you towards, one thing I'm not really looking at necessarily here is unequal enforcement of HOA rules. It sounds like that's something that is being addressed through perhaps a lawsuit. One of the things, though, I'm looking at is the allegations that Mr. Weatherhead's made that you are coming onto his property where it's either undisputed that it's his property or that HOA doesn't necessarily have any business to be there. So can you talk a little bit about those allegations?
So I believe there was, because like I said, he called me Friday. So we spoke about this again on Friday. I believe there was two. I think best I can remember, there was one time. He said there was two. I'm not going to argue. Maybe it was a second time that I went actually past where the easement is, even though the easement's in argument, that I went past the easement. And this was quite a while back last year, before I thought that the road went on past there. And I was down there, and even that is on a property line where I was walking. And then I came back and I actually found the marker. And since I found that marker, I haven't went back there in that area because I have no reason to go back there. I have been in this area that he's disputing, even though I'm sure it's not in dispute. I've talked to Public Works and everything else, but I have been in that area. But other than the one time before I found the actual survey marker and knew it for sure where it was, I did go back there.
Okay. Prior to finding that marker.
Correct. Yes, Your Honor.
All right. Was that in is that around the September 20th time he's talking about?
Yes.
Around that?
It might have even been prior to that, but around that point.
All right.
It just seems that he's talking about this rope that he put up, and he put a no trespassing sign on it, but he's put that up, and it's in the middle of the easement.
Okay.
So it's not, that's, I believe, what you're calling the disputed area.
Okay, thank you. Talk to me a little bit about the February 25th incident. And this is the one where Mr. Weatherhead is indicating there was a confrontation with his fiance and his father, and that the pistol was used, or the weapon was used, in an intimidating manner. So this is your chance to kind of respond to that part of it.
Yes, sir. So on that day, we had the meeting, the three of us went out there. I truly was hoping that Neil would be able to come, or that he would. And even though he said he had prior, I mean, it's all a volunteer thing. And so we didn't postpone it. We just went ahead and had it. It's been going on since September. So the first thing the three of us did was—
Can I ask you a question?
Yes.
Sorry, I keep interrupting you. I have in my notes, and now I can't remember if this is actually in your exhibit or not, that your email on February 19th indicating there was going to be a hearing on the 25th. Did you indicate that you would be on his property for that violation dispute?
It was in the location, time, because I gave him date, time, and location.
Okay. Do you remember the location? Was it going to be
End of Starflower, I believe is what I
put
in the email.
End of Starflower. Okay.
Turnabout at the end of Starflower.
Okay. All right. And that end of Starflower, that's this disputed easement area. Is that right? That's
the area he's disputing. Yes, sir.
All right. Go ahead.
So the three of us got down there. The first thing that I did is I wanted to show them where, the easement, which is there's a surveyed marker, and then 50 feet from that, it's 50, whatever it is, 50.8, whatever it is. So we measured that out, and that gets you to the center of the road on a certain azimuth. We don't have certified surveyor tools, but I believe the three of us believe that we would be close enough that it would be within a reasonable amount of distance. So we measured it out, and we even marked it 5 degrees each way so that we could have a variant, or a buffer. Then from there we measured out the 150. everything that was parked there was at 80 feet. So way, even if our equipment wasn't exact, way within the 150-foot easement. So after we measured everything out and marked it and took a look, so we wrote all that down, and we were in agreement that yes, all of this stuff is within the easement, within the roadway, blocking the roadway. So we took all that down into the violations thing. We were getting ready to leave whenever his fiance came in a little side-by-side deal. And then another car came in with her that I had never, if I had, I didn't recognize the man, Mr. Weatherhead, as Mr. Weatherhead Sr. So his fiance was speaking to us, talking to us. Not sure that the conversation really matters, but she was just asking us why we were bothering Mr. Weatherhead, and I was just trying to explain that we really didn't want to have to do this, but it was blocking the road, things like that. And then I don't remember exactly how, if I had asked who that was, and she said it was his dad, and I said he was still in his vehicle at the time. I believe his window was down, but he was still in his vehicle. And I asked if he was a property owner of the lot there. And his fiance said, no, he's not. And I said, well, I was asking him. I wanted him to give me a response. So I walked over there toward him, toward his vehicle, and asked again. And then he got out of his car, kind of stormed over toward me, and started saying, hey, you're trespassing. You need to get out of here. I wasn't really scared, but I believe that Ariel was nervous. That's my words, but she definitely took off and went to her van. I said, I was like, just calm down. We're leaving. We're done already. Anyways, we're leaving. And I went and got to my truck. I started it up, and then I seen Ariel in front of me, parked in her, just looking like she didn't know what she was going to do. Because you might be able to turn around. There's like a turn out. It's basically a one-way road, and there's turnouts. So there's kind of a little turnout where she was parked, but be somewhat difficult to turn around. And I got out of my truck and I said, do you want to come down here and turn around? And she was like, yeah. So I was like, okay, come on. And I stayed out of my truck, just waited for her to get turned around. Once she got turned around and left, I got back in my truck, pulled out, waited for Ted, for Mr. Weezy to get in his truck, and then we just kind of convoyed out of there.
Okay. Specifically, can you address the allegation that you brandished a firearm and expressed that you were doing so to intimidate them?
I definitely deny that 100%. I mean, as I stated before, I don't lean on my pistol, my gun. I don't touch it. I don't fidget with it. I don't want anybody to know that I have it. And also, that brings me back. I never said that I was there to intimidate anybody. I believe I never said that. Never said anything along those lines, because that isn't why I was there. That isn't why I've done any of this, Your Honor. I honestly wish I didn't have to do this. I took this role on to try to help the HOA out and get it back up and moving again. It's all volunteer. I don't get paid for any of this. I have other stuff that I could do.
All right, thank you. All right, who I'd like to hear from next is Ariel McClendon and Ted. Is it Weesey, not Weiss?
Yeah,
okay,
correct.
I'm sorry. I see you both on Zoom.
Hello.
And now you come off mute. Great. All right. Are the two of you able to activate your cameras?
Yes, I'll get them here.
All right. And looks like Miss McClendon was able to do that first.
Yeah.
And so I'll start with her. All right, Miss McClendon, can you please raise your right hand? Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
All right. So as I said earlier, neither you or Mr. Weissy are, Ms. Smith, yeah, thank you, are parties to this requested order, but I do find that your testimony is material and necessary to the decision, specifically because of your presence at one of the instances here where there's an allegation that the respondent, Mr. Sauerbrei, brandished a weapon and did so in a way that was meant to intimidate folks. So you were there. You're under oath. If you want to talk about that instance, I'd welcome your testimony.
Great. So we had showed up at this meeting that we had planned that was at Neil's request. And we had kind of just discussed everything, and I had not actually seen the area in question until that day. And so that was partially why we were there also, because I didn't really want to make a decision as a board member based on something that I hadn't actually seen. And we were there, and we had just finished up, and two vehicles rolled up very, very fast. And as we were leaving, And Neil's fiance approached us and kind of like accosted us and was kind of like accusing us, like, why are you here? What are you doing? And I remember saying like we were kind of just on our way out. But she kept engaging with us and wanting to talk to us. So the kind of sound that they were trying to just get us to leave isn't really accurate, at least as far as I was there, because like she was continuing to engage with us, and it kind of felt like they were there to have a confrontation with us. And they were recording us and just overall just kind of trying to, because like we were on our way out and we were trying to leave. And Neil's father parked forward in front of all of the vehicles that were parked in the turnabout, and I was parked further back because I was expecting to be able to use the turnabout to turn around. And so on my way out, because I just got to a point where they were continuing to engage with us and just kind of, it just felt like they were trying to cause a confrontation. It just felt like they were trying to get recordings of us. And they were just trying to, it was just not, it didn't feel like they were just trying to get us to leave. It just felt like they were trying to get something out of it. So I was uncomfortable because they were recording us and because Neil's father was just very, quietly standing there, or like in his car. It was just very odd, especially because we were on our way out and we were about to leave, and that is how I would have preferred it. I didn't really want to interact with anyone, especially not the person who had actually requested the meeting. So I went to my car to turn around, but then realized that I didn't really have enough room to turn around because they had placed themselves and their vehicles in a way such that it was kind of hard for me to do so. So I like looked at Wilbur since he was further up in a kind of like, am I good to turn around? Because it felt like they were making it harder for us to leave. And at no point in this interaction did Wilbur make his gun visible or brandish it or anything like that. And then I just turned around and I left. But
Did he, did Wilbur say anything that you recall that could be interpreted as, I'm here to intimidate?
not at all.
Okay.
It was the opposite. It was mostly Neil's fiance kind of just saying all sorts of stuff, and Wilbur just kind of calmly being like, no, that's not really what's going on. This is what's going on, and him very calmly trying to explain, but he didn't really say a whole lot, honestly. And we were kind of just trying to get out of there.
Ted,
All right.
What?
are you going to talk about why you were there?
All right. Thank you, Ms. McClendon. I'm going to turn it over to Mr. Weesey next. And so you heard there, Ms. McClendon sort of laid out why you were there. I think Mr. Sauerbrei did as well. And so, if you have anything to add, specifically too, from your point of view, I'm curious about if you observed anything that could be interpreted as brandishing a weapon or, doing anything intended to intimidate Mr. Weatherhead's fiance or father in that instance. So that's really what I'm looking for here as well. I understand that the reasons for being there. I think we've gone over that. I'm more concerned about behavior once everyone was there. So with that in mind, sir, if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
Okay, go ahead.
So like Ariel and Wilbur both stated, is why we were there. I was in the back watching everything take place as we were getting ready to leave, and by no means did Wilbur ever brandish his weapon or try to intimidate. When we were talking with everyone, I actually remember thinking to myself how calm and collected Wilbur was in a situation that was very kind of adrenaline filled because people were upset. And there was no intimidation factor, period. There's no brandishing a weapon, no hands on a weapon. I know Wilbur carries because, I mean, I'm always conscious of who I'm around in my area. But in the whole time I've ever been a neighbor with Wilbur, it's never been an issue, period. I mean.
Okay.
Okay.
All right. Thank you, Mr. Weezy.
Thank you.
All right. So, Mr. Weatherhead, I'll turn it back to you. This is your petition, so you get the last word. And, you know, you've had the benefit now of some testimony here. And so, again, I think you've probably gathered what I'm really focusing here on is allegations of Mr. Sauerbrey's behavior when acting on HOA business, to the extent you've alleged that behavior includes drawing attention to his pistol and in trying to intimidate folks. That's really where I'm focusing in on through this testimony. I know you weren't there on this February 25th instance, but I would also ask if that was part of a larger pattern of practice. You've indicated, I think, in your testimony earlier, so I know you've done this, but I want to give you a few moments to just say again, now that you've heard from folks, talk about anything you've witnessed as far as brandishing a weapon or comments from Mr. Sauerbrey indicating he's there to intimidate folks as part of, well, in any event, but sounds like as part of his duties as a HOA member or president here. So if you could talk about those instances specifically, I'll give you a few more moments to wrap up and make a decision.
Yes, Your Honor. I'd like to point out a couple inconsistencies to start off. First off, being with Ariel's testimony that she was scared initially, yet when she decided to leave, she was the closest to the exit of the property, yet she chose to drive all the way past everybody to turn around, and there's a turnaround where she was parked that I turn my dually around consistently in, so there's plenty of room and a hammerhead about 100 feet just south of that. So that's a little bit inconsistent to her being scared to go towards them, yet drive right past and through them at that point. I'd also like to point out that Wilbur made a written testimony that he submitted to you stating that he never carries his pistol while conducting HOA business, yet today he just agreed that he was carrying it, but he didn't even touch it or anything. Obviously, both my father and my fiance knew that he had it, so if he was concealing it, he wasn't doing a very good job of it, and it's our understanding that that was on purpose. I would also like to point out the emails that I have submitted, which is all the emails and correspondence with the HOA since September, has shown a clear history of me being cooperative. Wilbur Sauerbrey and I came to an agreement even back in September that I would move the rope further down as far as I could towards the property line, and that was agreed upon until several months later he decided to escalate it again. And this leads to my point that he has a history of escalation that started with the rope was just in the wrong spot, to my garbage cans were out too long, to I was conducting business without permission, yet I had permission from the previous HOA board, yet he was trying to revoke it without cause. And when I requested permission for business activity, he said it wasn't good enough based on rules that they had just enacted without proper voting by the members of the board. He tried to enforce fines that were also not voted upon by members of the board as per the CCNRs, and hired a towing company to tow my things away. Again, not voted upon by the CCNRs. And this instance that's in question, whether he thinks he was showing his pistol or not, he was, and it was evident that he was carrying. And I believe my dad and fiance that they heard him say that he was there for harassment, and I could make that out from the video that my fiance had, but I could see the how somebody that hasn't met Wilbur might not be able to make that out with how shuffled it was, because my fiance was walking at the time that it was said. So in conclusion, I did reach out to Mr. Sowerbury this weekend in an attempt to not waste the court's time and to come to yet another agreement that I would move the vehicles out of what they're claiming is an easement while we litigate this further in a civil matter. Yet they refused to, and immediately after our last hearing, his wife went straight to Facebook, was slandering me. And again, last night or the day before, another member of the community was slandering me based on my petition that to just do away with the HOA completely. So this continues to escalate, and I don't want it to get to a point where he shows up on my property with a weapon, because I also conceal carry, and I don't want that situation where I feel threatened by him and have to act accordingly. And I don't want to put my family or my kids in that situation either. So the request for this anti-harassment is to give me time so he can't continue to contact me, continue to threaten to tow my vehicles or place undue fines and fees on me that kind of hinders my progress towards finding a solution to these problems that we're having.
All right, thank you, Mr. Weatherhead. So I'm going to deny the petition for protection order. The reason being, generally speaking, I think that the allegations against Mr. Sowerbury are grounded in, I think, some issues with HOA enforcement, inconsistent allegations of maybe some procedural unfairness, unequal treatment, things of that nature, that are just simply not, this is not the forum for that. This is an anti-harassment protection order, which may carry criminal consequences if violated. You know, for these, there needs to be more than kind of disputes over operation of an HOA and easement areas and things of that nature. To the extent there's been allegations against Mr. Sowerbury that he's gone onto Mr. Weatherhead's property trespassing, it sounds like there may have been an instance or two where Mr. Sowerbury may have gone onto your property. I don't know if there's enough evidence here that was intentional and part of a larger pattern of practice of knowingly going onto your property without, and I understand this is disputed, but sort of without conducting HOA business or into an area that the HOA believes there's an easement and they have a right to be there. It sounds like a lot of the allegations around trespassing and around things like spray painting and things of that nature and taking pictures is a dispute over whether the HOA and Mr. Sowerbury in particular has a reason or authorization to be there. And with that dispute in mind, that this is not the forum for that. Really, what I'm focused on is whether or not there's been a showing that Mr. Sowerbury is engaging in behavior with a firearm intended to intimidate you, Mr. Weatherhead, and your family in carrying out some of those duties. And at this point, I don't think, Mr. Weatherhead, you've met your burden of proof to show it's more likely than not that Mr. Sowerbury's actions here rise to the level of intimidating or creating a hostile environment based on, it sounds like everyone knows, he's somebody who has a concealed carry pistol license and does carry. That by itself isn't going to create an environment that gets a protection order. You've lodged allegations of him excessively touching it, maybe doing so when things are getting heated. But there's also been testimony to the contrary. And so I'm not in a position to say it's more likely than not that Mr. Sauerbrei is engaging that kind of behavior that necessitates a protection order. So, on that, I don't find that there's been any knowing and willful course of conduct without a legitimate or lawful purpose at this point that creates harassing behavior causing substantial emotional distress. I think most of these issues are being maybe worked out in a different legal forum than this, but I don't find there's enough here for any kind of anti-harassment protection order. Do you have any questions, Mr. Weatherhead?
No, Your Honor. Thank you for your time.
All right. Thank you, sir. You're free to go. Thank you to the witnesses who are here today. You're all free to go. And Mr. Sauerbrei as well. You are free to go. I believe, is there a temporary order in this case? There was
No,
not.
Your Honor.
Okay, then that one, nothing to rescind there. So the order simply won't go into effect. So there's no protection.
Your Honor, one question, is there a point where if this continues, there's some kind of, what would I do? Would it be a civil issue?
Everyone is welcome to file protection orders. That process is outlined in some of the materials you were served. And so, again, you're welcome to file a petition as well. It sounds like maybe some of these issues are being worked out in court, but yeah, no, that you're able to do exactly what he did. Everyone and anyone can file a petition, and then a judge would take a look at it.
But for me, it would be more of just a civil case, not something like this, probably. I wouldn't be afraid of him. I wouldn't not want to.
I can't give you legal advice on what to do. I can tell you, this is available as a forum for you. Resolving property disputes, that's over in Superior Court. But yeah.
Or if somebody continually accusing me of harassment and then it being found that it's not real. That's more of the civil matter.
Well, that is something you need to talk to a lawyer about. Yeah. So, all right.
Okay.
All right. Thank you all for being
Appreciate
here.
it.
So I have two cases I want to call here. Deerfield Estates versus Emilio Castillo, 2504-285. And then I have another one with your office, Mr. Capitan, that is Deerfield versus Castillo. Come on up here. That was just handed to me. Deerfield versus Castillo, 2600-528 for non-payment of rent. Did you know that was pending?
Right to the podium, sir. You're next to me.
Did you know that was pending?
I don't think that there's a pending case on the non-payment.
Yes, there is. And
There was a judgment going on, wasn't there?
well, that's still pending.
Okay.
There was a judgment entered on March 5. Why are you guys filing two separate actions?
You have one, he hasn't made rent. And the other one is he's not following community rules. They're separate and distinct.
Did you know about this other case?
I didn't.
Why didn't you? Well, let's take care of the one I was out on, first of all. What do you want to say, Mr. Captain?
I was out there this morning. There's dog excrement that's sold, but there's actually blue brought in it. All right. I have photos. If Your Honor would like to see it.
I was out there.
Yeah.
I stood right next to you. I didn't see enough. I'm not throwing him out based on what I've seen. He's cleaned the property up immensely. So
let me ask Your Honor this.
you don't have to ask me anything. You can make an argument to me. You're not going to ask me anything. Go ahead.
So every single time that Mr. Castillo, he doesn't follow community rules, procedures. The only way to get him to do this is to get the court to have a judge go over there and look at his property twice. That's not right. Okay?
Okay.
No, that's not. So this is the promise keeping business. And Mr. Castillo has not kept his promises. We have. He has. I believe that we've proven enough just through the course of this individual case.
What was wrong with the property today?
What was wrong with it? Well, from the short time that I was there, the first thing that I looked at was dog food right on the overgrown lawn. You can
Overgrown lawn.
You want to see that? Go on, you're doing.
Mr. Kevin, tone it down. I'm sorry. You're not going to argue with me.
I'm not arguing.
You're not going to yell at me. And I was there. I saw it.
Okay.
Let me see your photograph that you're going to tell me makes the lawn overgrown in the middle of March or the latter part of March.
Please.
I don't know if it's possible for a lawn to be overgrown in the latter part of March. What was that? What is this?
There's your dog excrement. It's been sitting there forever. And the reason why it's long is because he had to cut it. So it's been like that through the whole winter.
You got here, failed to maintain the exterior of your home and home site in accordance with the community rules and regulations by failing to paint or stain the steps, failure to power wash the home shed and awnings, failure to maintain landscape, failure to remove improperly stored outdoor items. I think those are pretty well done. Failure to remove debris and bulk items from the yard. Other than on the porch, where he had some things that I'm not excited about that aren't going to rise to the level of violation of community rules and regulations, I didn't see anything that was that bad. Failure to replace damaged window treatments. Failure to maintain the general clearing appearance of the home sites. You're asking me for a just cause termination, and I'm not going to blame. There's not even a triable issue here at this point. I'm dismissing this case. Case dismissed. And Mr. Castillo, listen to me. He does raise a valid point. You can't live in a community. Now, if you lived out in Monroe County on your own property where there's nobody else, do what you want. I mean, as long as you're complying with city or township ordinances. You can't do this in a community. And I've gone on my way here. He's correct to go see the property twice because I hate to see you lose the home. Now, I'm going to tell you something. I'm going to remember this case, and it's going to come in front of me if it comes back here. And if I have to go out there and look at that property, I mean, this is twice, right? I went last Monday and this Monday. I'm going to remember it, and I'm not going to be forgiving about it. Do we understand? Fully and complete. Now, do you have the money to pay on this other judge?
I absolutely have all of it.
For the lot rent?
Yes, absolutely.
How much you have? This judgment, and they brought it to my, honestly, I don't remember every case I call here, okay? I mean, there's a lot of people with a lot of familiar names and sounding names, and I did not remember this was you, or I probably wouldn't have granted this, but I got this back in February. They never filed an application for a writ. This is for $1,766.73. Do you have that to pay?
I haven't looked at the people, right?
Judge, just to clarify, Judge, they did file a writ. It just has not been signed yet because we had court today.
I see. Huh? I see. You have that to pay today? Pardon?
If you read how.
Get the money. How do you have the money? Are you prepared to accept the cash?
No, because if it's past the 10 days, he should have paid it, Your Honor. And we demand a writ. I mean, that's what the law requires.
Why didn't you pay this?
I didn't pay due to notice advice. Keep all contact with because they had held my rent when I sent it in December. After being after judgment to put it in for the 26th, I put it in. It was held until after the 2nd. It wasn't cashed due to this circumstance right here, usually filing for this.
Okay, so you filed on the other one. They weren't accepting the rent.
They didn't accept my rent. I put the money orders in and they weren't cashed until after the new year. I had put them in on the 26th when I ordered and they weren't cashed when they returned to the office. So I was advised to not.
Are you on this, or do you want me to get the lawyer that was on this? I don't know who was on this.
Yeah, I wasn't. Yeah, I don't know what he's talking about. It doesn't even make sense.
Well, I'm not signing the writ without a hearing. So, Jennifer, I told you what I'm doing. I announced what I'm doing on the termination case. And on this one, I want you to set that. We don't know who was on this case.
Your Honor, if you're up, would like to just maybe hold off, maybe a half hour. I can get prepared for whatever questions you have.
Well, you can get Mr. Levine. Mr. Levine's on the case, it looks like. It looks like. I could be wrong. I don't know who was on this. Who's got, it looks like a 3P number.
Oh, 3?
It looks like. It could be 6-3. I don't know. Looks like a parentheses and then 31797. I'm going to show you this signature. Maybe you can tell who from your office there is that signature.
No, that's it.
What was the P number?
Looks like David Levine, he's 31797.
That's what I was thinking.
Yeah, he's in Florida, so.
John Arkin,
Oh,
John Artoon?
1797.
Is he with your firm?
no, that looks like David.
If they want to send you, they can send you. When did their office refuse to accept rent?
They took my money order. I turned it in on the 22nd.
Of what month?
26th of December. They won't cash till after January 2nd. I called on January 2nd and had no cash. I know I called probably I believe it was 2 days later. It didn't apply.
Well, why didn't you pay the February and March rent?
I was told to just leave everything in.
By who?
I called them. They told me to.
Okay, I don't want you to know. I don't want to know what your lawyer told you. You're going to have to file a motion to set aside the default. That's what's going to happen. And I'm going to set the date for motion for entry or for entry of a writ. I'll set that for hearing your application for a writ. So we'll set the hearing on application for writ, motion to set aside default judgment. Jennifer, I want to put this in next week sometime if I can.
The 30th at 9:30, next Monday.
Which one?
March 30th at 9:30.
Technically, he's required to e-file it that day. Why don't we do this? Why don't we do it on the 1st of April? Can I fit one in there?
On Wednesday.
Yes.
Let me just pull that up.
So you file your motion to set aside default judgment today. You understand?
No, I don't.
You're going to file a motion to set aside default judgment on this second case, the one I just called, 2600528. Hearing on application for writ and motion to set aside default to be set for what day? April.
You want April
1st?
1st, 10:30.
at 10:30. What do I have that morning?
You have Brownstown. There's an
That'll be-
arraignment at 10:30, so
That'll be
and then-
fine. That's what I'll do. So you guys can, I don't know who's going to appear on this.
By Zoom, Judge?
Pardon me?
by Zoom.
Yeah, you can appear by Zoom.
Okay.
But I think I'd like you bring your money. You understand?
Yeah.
I know. Well, don't forget it. You come in person. Although they won't have anybody here in person. I'll figure it out. You bring your money.
I have a pay today.
Not really, because you have a judgment you didn't pay within 10 days. Okay? I've never seen firms, though, Mr. Capitan, file two separate actions, a just cause termination or non-payment of rent. They're ongoing at the same time. And if they're going to do that, there should be an indication to the judge, and the second filing should have to say there is another action pending. So I was just told you got another one there. One's in front of me and one's in front of Judge Hess. I'm not saying you, but your office. I've never seen them do this before. I've never seen any office do this before. So I don't know if there's just a some kind of misunderstanding or what have you, but I've never seen that happen. That's all I'll say about it.
I'm sorry, this is the first firm that's landlord-tenant that I've been with. I've practically seen federal.
I've never seen them do that before. But anyway, we'll work it out next week.
You gotta take that phone out of here.
The phone has to leave, sir. Got to take the phone out. Phone's got to leave the building now, please. Guys, please. Sir, phone out of building.
Yeah.
We got signs all over. They have to be muted. All right, that's what I'm doing. Thank you both. Have a good day. Thank you. Robert and Julie Audie versus Samantha Gordon and Ian Audie. 2600701. Come on up to the podium. I'm not sure I'm understanding this one. What time? This was scheduled for 8:30. I don't have the defendants here. What's your name, man? Sir, what's your name?
The
So,
defendants are on Zoom, Your Honor, and I think this was heard last week, and then the plaintiff did not appear, so they filed a motion to set aside the dismissal.
your names, please, people, Mr. Audie and Ms. Gorman?
Samantha Gorman.
Ian Audie.
Is this your son?
Yes, it is.
And the relationship between, and that's his girlfriend, is it? Okay, now, I am so sorry about your son passing away in March 2 of 25. Well, why didn't you guys call and tell us, hey, listen, that's a bad day. Can we move to it?
Think about it. I was not in the right frame of mind, and I apologize to you.
Your Honor.
No, not yet.
Okay.
What portion of the house do you rent to them?
So they were going to get evicted out of an apartment. So my husband and I wanted to help to get them to try and get back on their feet once again. This has been continuously. They moved in and it turned toxic quickly. I have been called a C word, a B word. She has yelled at me that I'm F and B. My son has told me he's going to have the grandkids leave marks on each other and call the police and tell them that I did it. It's just a toxic living situation. I don't even feel safe anymore living in the house. Unfortunately, we've tried to help. This is the 18th. We had Flat Rock out. One of my daughters had. She was on the phone with me. He was having. I don't even know what you want to call it. He was out of control. So my son can. So my daughter called for a welfare check. Flat Rock came out. They took him to the emergency room for psychiatric eval. It's just not a good.
How old are you, Mr. Audie?
37.
You work?
Yes, I do.
Ms. Gorman?
I am 30. I'm sorry, 35. To be honest, I was an addict for a long time. I've been sober for a year, so I've been putting in applications, been going to interviews. She gave me until June to get a job, but then she she came at us in January and was accusing us of a lot of stuff, and she started threatening eviction. We were supposed to start paying rent to her in January, but the beginning of January, she started threatening eviction, saying she was going to the court to evict us, which she did end up doing. So that's why we never followed through with paying her the rent. And when it comes to
make sure that I understand all of this.
So you're right.
Wait. You guys lost your residence prior to moving in with your mother. Is that true or false, Mr. Audie?
True. We had moved out.
And when did you move out of the other place?
That was in October, late October.
And then you moved in with your mother and father, the two of you, correct?
And our 2 children.
And so you've had 6 months where you've been there, and your 2 kids have been there, right?
Correct. Or just under 6 months.
I got it.
But the original, sorry, Your Honor.
Mr. Audie?
The original.
Mr. Audie? I want you to listen. I don't know. I guess I'm old school because I only had one mother and one father. And it sounds to me like they tried to do you a favor and it hasn't worked out. That's what it sounds like to me. And it sounds like to me like if I was the son, or even if I was dating the daughter of the owners, that I would be saying, you know what, I'm not going to make you go through a court proceeding. I'm going to go ahead and move out voluntarily because that's what adults do.
That was honestly the plan, Your Honor.
Mr. Audie, I'm not done talking to you.
I didn't know that. Sorry, Your Honor.
So I'm going to make this easy. I'm setting aside the dismissal. You got to be more careful in the future. Okay. I know. That's what we do. How old are your kids, Mr. Audie?
13 and about to be 16.
I'm sorry, 13 and 16?
Correct.
Yeah. Well, that's good. And it's good that you got kids, but they got to come first and foremost at this point. You're like way down the totem pole, as I've always thought that I am with my kids.
That's why we came
So
here.
it's incumbent upon, well, yeah, I know, but the parents did you a favor.
Right.
That's what they did. That's what parents do. And actually, maybe they could be faulted for bringing in a 36 or 37-year-old man and his girlfriend or fiance or whatever you are, wife and 2 kids. Maybe they could be faulted. Maybe we could do that at 21 for them, but at 35, 36, I wouldn't be particularly resolved to bringing in 4 new people to my home, but that's just me. I mean, I feel like when we've raised our kids to 21, 22, we do the best we can. They're on their own. So I'm going to make this really easy. I'm going to set aside the dismissal and we are going to have a hearing right now. If you tell me, Judge, I want to have the hearing tomorrow so I can prepare, then you can come here and I'll accommodate you and I'll make the hearing tomorrow. But you folks need to toughen up.
I agree.
Yeah.
I mean,
Agreed.
I'm
So
telling you right now, it seems to me that this woman is terrified. And don't either one of you tell me whether she should be or not, because I can tell by looking at her that she is. She had to call the police. So you guys just want to voluntarily enter into a consent agreement now where you can get out of there in 10 days?
Yeah.
As the longest we can get, yes, because as of now, we had money saved up to move out actually, but our transmission went out on our car. We just paid that. We are showing his dad the receipt for that. And as of now, we will be in our car and my kids will be at my mom's. So the longest we can get to save up as much as we can. If 10 days is all we can get, then that's all we can get. I understand. But
with the eviction, there's not much I have to say besides it's not the full truth on what's being said. I know you could say she's
Did you ever
scared.
pay them any rent?
But we understand that it's
Yes or no? Did you pay them any rent?
we had an agreement with her to pay rent, but then she
Listen to what I'm asking. I'm talking to Mr. Audie here.
Yes, sir.
Did you ever pay them any rent?
I tried and she said no.
I didn't ask you if you tried.
Then no.
I didn't ask you if you tried. I asked you if you ever paid them any rent. So your answer is no, correct?
She wouldn't take it. I had the money and she would not take it.
But you didn't pay them, right?
But she won't. I can't pay someone that won't
that's
take
what mothers do. Because mothers and fathers love their children unconditionally. Stop, Ms. Gorman.
I'm sorry.
Well, you guys should be appreciative from the highest mountain for what they've done.
We are, and we have.
Ma'am, you're way too involved. And if you used any of that language toward her and you were my wife or my significant other, I wouldn't be with you another moment. If anybody called my mother any of those names, if she's telling me the truth and she just doesn't strike me as a liar, I'd never be with that woman.
Okay.
And now you're coming in here and you're getting boisterous, and I'm trying just to talk to Mr. Audie because he is the son. And let's be clear, you wouldn't be there but for him.
I apologize.
All right, don't say anything else unless I ask you. Will you do that for me, please?
Yes, sir.
Bring me a judgment form, Jennifer. Leave it blank.
It's on its way.
Thank you. You need to get a job, ma'am. I'm glad you're sober. You said you've been sober for a year, but at some point you got to get back into society.
Yes,
you're mid-30s. You should be working. And then you won't have money problems. Then you won't get kicked out of homes. Then you won't have to worry about where you're going to come up with the money to buy the next place. I mean, this is just fundamental life 101. That's what this is. And look at your dad. What you got a condition of some kind? Yeah. He's here. He's dragging the court here, and you guys are where at the house?
Trust me, I know, Your Honor. And as you could speak to my dad, me and my dad have a very wonderful relationship. He did not want this to happen, and was pushed by my mother. And like I said, we have
Mr.
me and my
Audie.
mom. Okay,
Mr.
yes, Your Honor.
Mr. Audie. Save it, please. Do you want this to happen? Do you want him to be out, Mr. Audie?
It didn't have to be this way, but at this point, yes.
Did you ever hear Mrs. Gorman call your wife those names that she referred to?
Yes, and I heard Ian, like.
You talked to your mother that way? Mr. Audie? You talked to your mother that way? Are you kidding me? I'm sorry I asked that question. I just think differently of you now.
I have said those things in regards to her.
Then save it.
Children.
Save it.
Okay.
Gosh, I can't believe you would talk to your mother like that.
See how she talks to her grandkids.
Hey, listen.
I'm listening, Your Honor.
I don't want to hear it.
Okay, I'll stop.
Thank you. So I got a young judge that's going to come here and tell me what to do now. She's a really bright lady, Judge Johnson here. She just got appointed in Taylor. Here's what I'm doing. This is not right, Mr. Audie. Ms. Gorman, this is not right. I'm setting aside the dismissal. I'm entering judgment. You got 10 days to get out. I don't expect anybody to be saying a sorry word toward your mother or mother-in-law or whatever she is to you, Ms. Gorman. I expect there to be peace and tranquility. And I'm going to sincerely hope that the four of you will use the next 10 days to patch up whatever differences so that you can enjoy a relationship as you should with your mother and mother-in-law, and she can, and your father can, with the grandkids. And you ought to apologize profusely for ever calling her any of those names. You don't have the right to do that. Are you kidding me? I don't care what she did. But again, I'm old school. I'm thankful for it. Judgment's entered. If they're not out by April 2nd, I've filled out the judgment. We're going to send a copy to everybody. If they're not out by April 2nd, on April 3rd, you come in here with an application for a writ. I will sign. And then the court officer, I'll make sure they go out the 3rd or the 4th at the latest and get them out of there.
So they have 3 kids and a snapping turtle that they want to stick me with.
You're going to take that stuff with you.
No, we don't.
I never said that, Your Honor.
No,
Take them with you.
absolutely.
If you don't take them with you, I don't even want to tell you what the alternative is. You don't want to do that. John just goes in there. Take them with you.
Yep.
And you don't have to wait until the 3rd to be, or the 2nd to be out either. Did I put the 2nd and 3rd on?
Let's see.
2nd?
Oh, yep, 2nd.
Okay.
Yes, Your Honor.
I hope you'll apologize. Ma'am, you need to get a job. Good luck. Thank you.
Thank you.
Good luck, folks.
Thank you.
Okay. I want to go on to this case here. Where's the one with butlers? Jennifer, was that? Yeah, Anthony Butler versus Paul Robertson and Shauna Robertson. This is 2600122. Everybody's name.
Anthony Butler.
Skylar Crenshaw.
Shauna Robertson.
Paul Robertson.
Do I have a copy of the judgment in this file, Jennifer?
Judge, I'm not sure if we printed it, but I can get it really quick.
Would you do that for me, please? Now, I know that they probably gave me bad information down in the civil department. I'm sure they did. But I don't want to say anything until I see the judgment. So they're going to bring the judgment to me. And I just know that you guys didn't miss a payment, Mr. and Mrs. Robertson. You wouldn't do that. That would just convince any judge that has the ability to count to 3. They would recognize what kind of game you've been playing this whole time. I just want you to know. So I'm sure they didn't. I'm sure they didn't update me. I'm sure you guys paid. I just need to wait for the file to come here, and you ought to be completely ashamed of yourself if you didn't pay on time, and if the civil department didn't update me because the payment was made a day or so later than it was supposed to be. I know you would be ashamed. I would be ashamed. I wouldn't want to walk out of my house, but that's me. So I don't know what's going on over there, but I think you guys just have taken this and prolonged it. But I will reserve judgment until they bring me the files. All right. Anthony Butler versus Paul and Shauna Robertson, 2600122. You can read this. Everybody's name.
Anthony Butler.
Everybody's name, please.
Anthony Butler.
Skylar Crenshaw.
Shauna Robertson.
Paul Robertson.
You guys pay these people or not?
No. We didn't.
Shame on you.
Well, there's more to this situation that's still not being said, but my husband was hospitalized. He has ongoing health issues right now. He just got out of the hospital and since then lost his job. So this isn't just us not wanting to pay. There's bigger things to this, and we've been saying that all along, but it's not being heard and nothing's being taken care of. In the process of us trying to move out, which that's the process right now.
Slow down.
The basement has flooded once again.
Slow down. Now you're going to get aggressive with me, huh?
No, I'm not. I'm just really upset because I feel unheard.
Stop. Don't tell me this stuff about not being heard. You want to tell some judge that, some court, you tell them that. I'm not going to listen to that. I heard everything that went on. You guys reached this agreement. You were supposed to pay and you didn't pay. And now you want to get aggressive with me? Are you kidding? You think I'm going to listen to this? Stop. Do not interrupt me. Do not interrupt me. I feel like it hasn't been heard. Nonsense. I listen to every word that comes out of every person's mouth and I give them multiple opportunities. And now you want to start to be aggressive the other way because I'm calling you out on going back on your word? Seriously? Don't play that game with me. Do not play that game with me. I can see exactly. I've been doing this too long. And I don't mean too long where I can't do it. I mean too long where I can read everybody like a book from cover to cover. And you guys have been playing games with these people. That's what you've done.
Can I say something, Your Honor?
No, you cannot.
Okay.
We were prepared for trial. You guys resolved it. When did all this happen? I signed the judgment on February 23rd. When did he lose his job? And when did he go in the hospital?
He lost his job 2 weeks after the judgment, and he was in the hospital all last week.
Do you work?
Yeah, I work midnights.
Where do you work?
I work at Henry Ford St. John down in Detroit.
All right, well, here's what I'm going to do, Mr. and Mrs. Butler. I can't really go back on this. You got a money judgment for $9,500. They were supposed to pay you $2,000 by February 27th.
Bye-bye.
Which was after he lost his job, right? Was that after he lost his job?
Yes.
So him losing his job had nothing to do with the fact that you didn't pay the $2,000 as agreed upon, did it?
No, but we have.
Well, then why'd you try to put this off? It's nobody's listening to me. Don't play that game with me. That had nothing to do with anything. I mean, you don't have to be a legal scholar to see what was going on this one.
Your Honor,
Folks, here's what I would do. I'm not going to listen to this. You can't, based on the fact that you did this on your own, you can't have a writ issued until they have to move out by March the 31. I'm going to tell you what I would do. I would come in here the morning of April 1 with an application for a writ. Jennifer, you're going to tell me I'm coming down there and signing it, and you're going to have the bailiff ready to go out and execute on that judgment on the 1st. That's number one. Number two, I would subpoena them for a creditor's exam, both of them. And then they're going to have to come in with all their documents and all their wage info and all their bank accounts. And then you can start garnishing her wages. And when he's employed again, his wages. That's it. I wanted to just call this up because I knew you guys called the civil department and asked what I could do. I looked at the judgment. I said, I knew they were being duped. And actually, it was probably my fault for not advising you better. And I don't want to advise either party. I'm not supposed to do that. But I saw this thing coming here. So that's why when I hear somebody get aggressive with me, I'm not going to be quiet about it. Enough said. That's the end of that case. Thank you. People against Tarek Anthony Kuczynski, 22F237131. Good morning.
Good morning, Your Honor. Sherwood Management Chair Simpson, away from the reading stand.
All right. So where's he been?
Judge, he indicated he wasn't aware of this matter 2022. There's updated address on the file. He said he was not living at the address that was.
Where was he living? Where do you live?
In Southgate, Your Honor.
What's your address?
16515 Grace Court, apartment 107.
16515 Grays Court,
Grace Court, yes, sir.
Judge, I've got a sticky note on the file.
Oh, I understand.
Oh, I'm sorry. Thank you. Grace Court. I see. Grace Court. Well, you still haven't changed your address with the Secretary of State to tell him that's where you're living either.
Yeah, he needs to be with the governor. He's right today and it's got an old address on it, so he's going to take it.
Is it 48195?
Yeah.
Let's see. Back at the time, you were living at Telegraph Lot 19. That's where all the notices went in 22.
Yeah, that was my mother's house. She passed away right around that time.
What do you mean right around that time?
February 2022, right around the time I was leaving there.
Look, I'm going to give you
that could be like.
I'm going to give you a personal bond, okay? But don't play with this over here, okay? No contact with the victim, no contact with prosecution witnesses. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. Tariq, where does he work at?
Just do gate work right now, Your Honor.
I'm sorry, gate work?
Yeah, like delivery driving.
Okay. Let me just see something here. 22F237. How much money do you make?
It really depends. Depending on how.
Well, on average, how much do you make?
500 on average after taxes.
All right, you're not to enter the premises or go near the premises at 25821 Telegraph. That's where he allegedly. I don't want him to comment about it. So this was his mom's in February. And he was in April. I'm sorry. Yeah, in April of 22. They think he was throwing a brick through the window. Back window of the victim's car. I don't know who that would have been. I don't want to know. Lot 15 in Flat Rock. All right. So also you have to go over to the Flat Rock Police Department to be fingerprinted and photographed today. Okay.
Okay.
We're going to give you an order. It's going to be by 1 p.m. today. All right.
Okay.
And that's it. And we'll give you a court date. And if you want to petition for a court-appointed lawyer, you're going to have to fill one out. Okay.
Okay.
What do you have for me? I think I have it written on here, I think. April the 2nd. April the 2nd will be your pretrial date, and that will be at 9:45. Okay?
Yes, Your Honor.
All right. Any questions?
I know I have other outstanding money I'd like to pay today. From previous cases from 2018.
That's a good idea. How much do you owe the court?
I believe around $1,000 total.
So you haven't just, it's not that you got notice, didn't get notice, you just didn't want to come and see us. That's all I got to say. Go down the hall, take care of, you got other ones here. I'm sorry. Okay, we also got 18F228616A.
I have that number again, Judge.
18F228616A. And then he was in front of me in October of 21, and I ordered him to pay. I extended his probation till March the 16th of 22. Got some problems here. So all I've got here is fair to pay fines and costs balance owing $690 right now on that one. Yeah, you've been really fooling around with us, haven't you? I hope you've enjoyed yourself. I've also got 18F228616B. Wow, pled guilty. This is what he did, Mr. I don't know if I'm going to give him personal bond on the other case. Pled guilty to failure to pay $257. Defendant pay $257 by 4 p.m. or appear tomorrow, October 26, 21 to serve jail term. Never appeared. Ooh. Ooh.
Yeah, that's weird.
Yeah.
There you go. So just we're looking for a balance. He did come in today and he's prepared to pay the whole.
Yeah, he's still going to have to pay a bond. So he's going to pay $261 on that case. Is that what he owes on that one now?
Judge, is that on the B case?
Yes.
He has a balance of 302.
He's going to pay $302 now or serve 31 days. And on the other case, I assume he's going to admit that he didn't pay the $690.
Yes.
If you plead guilty to that charge, I want you to understand your probation on that could be revoked. You could get 93 days. Actually, I think I already, extended his probation. Do you understand that?
I'm sorry.
Do you understand if I find you guilty of failing to pay $690, you could get 93 days. Do you understand that?
Yes.
You're entitled to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
To the charge you failed to pay $690, how do you plead?
Guilty.
Did you fail to pay?
Yes, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Boy, you got a lot of gumption. Then you come in here and you tell me that you didn't know because you moved. You were in front of me in 21 and you had the audacity to come in here and tell me that you're just here to pay when I told you to come back and pay that day or serve bail and you didn't pay. That wasn't a good decision.
Yeah, I know.
Going back on my bond on the destruction of property. So you're going to pay the $690 or serve 93 days. You're going to pay $302 or serve 31 days. So right there's $992. And then I'm not giving you a personal bond now that I discovered this, $5,000, 10% on that one. So I hope you got somewhere in the neighborhood of $1,500. If you don't, you're in custody. I'll give you an earlier court date if we need to. Is there an earlier court date for him, Heather?
If he could not post, Judge Hesson has Flat Rock on the 26th.
Can you post? Judges don't forget. I'll treat you fairly. But judges don't forget when they go out of their way to try to help somebody and then they don't show up. You got it?
Yes, Your Honor.
Apologize. All right.
In the court's time.
Good luck. LBNB versus Kimberly D. Carroll, 2600-124. Appearance, please.
Good afternoon, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff LVNV Funding.
And Your Honor, defendant has not checked in with me on Zoom.
Okay, well, you filed a complaint. I mean, she sent me a letter, additional time to develop a plan, but she's got to be here. You want to default?
I do, Your Honor.
Go ahead.
Damage amount on this account is $1,788.80. We've incurred court costs of $75 filing fee, service fee of $58.05 for a total cost of $133.05. So we're looking at a total judgment of $1,921.85. And I'll get that filed later this afternoon through my file.
Here you go. See you. All right. Mr. Gruen, always a pleasure.
You as well, Your Honor.
You see this new judge next to me, Judge Brittany Johnson. She's going to be in Taylor. She just got appointed. She's a smart cookie.
I was in Taylor this morning, so I was dealing with the visiting judge again. So it'll be nice to have a sitting judge back on the bench.
Who was sitting there today?
To be honest with you, I'm not for sure. I never saw the judge, so.
Judge, if I may, really quick, I have an iPhone here that I haven't been able to identify.
Oh, on the iPhone there. Sir, ma'am, can you start your video and tell us your name, please?
Oh, I've
only done one of these
It might
before.
be-
My name is Kimberly Carroll. I'm sorry.
There
I was
she is.
sitting in some room or something, and then I didn't know. I was just sitting there staring at myself. I'm sorry.
Oh, boy. All right. You got to have your name on there, okay?
All right, how do I do that?
Well, you got to start your video right now.
All right, let's see.
Let's start with that. I just entered a default judgment.
Is there as me?
You cannot be driving, ma'am. What are you doing? Come on.
I'm not driving. I'm a passenger in a car.
You're still not, I'm not hearing cases with people driving or as passengers in cars.
Okay, I will pull over right now.
Short of us coming out to everybody's house and doing these on boats and stuff in the summer, I don't know.
I'm sorry, I have an emergency. I'm going out of town for a family member, but I will have my driver pull over. Hang on 1 second. I'm sorry. I didn't know that I wasn't allowed to be in a car, but hang on 1 second.
Am I crazy or does it not look like you're driving that car?
I'm not driving the car. I'm a passenger in the car, sir.
What side of the car are you on?
I'm on the left-hand side.
How would you be on the left-hand side if you're a passenger in the front seat? Am I missing something?
Right-hand side. I'm sorry. I've been sitting in a room. I didn't know.
Yeah, the seatbelt's coming off of the driver's side. Right? Now you're lying to me, right?
No, I'm not, sir.
Never show you the driver.
Let me see the driver. Let me see the driver.
Hang on 1 second.
Now.
I have to ask their permission.
Now.
Oh my God.
Oh, you're not in the you weren't in the driver's side. Do you think I'm that stupid? I'm going to go ahead and enter a default judgment. Our paperwork says that we can't that they can't drive. Does it not, Jennifer?
I'm sorry, Your Honor. I took a breath in and started choking. Well, I missed what
Does
you
our
said.
paperwork not tell people that they can't be in a car?
I don't know, Your Honor. I'd have to look at it
The
again. I haven't
paperwork
looked
that
at it in a
I'm
while.
looking at, it does not say that I cannot be in a car.
I'm entering a default judgment. You lied to me. Judgment 1921-85. Send me your counsel and put in there defendant was not available at the time and then was driving a car and telling the court she was not. I'm entering a default judgment. Have a great day. Thank you.
Thank you, Your Honor.
I signed in at 1:30, sir.
Well, you got an attitude with you. I'll tell you that. You got an attitude. I'm not putting up with it. Nonsense. Good luck to you.
All the attitudes. All the attitudes today. I mean, how many people can come into court with that kind of attitude with a judge? I just don't get it. It is indeed. Wait. Why? Oh my, oh. I see what's happening. I'm an idiot. I'm an idiot. Hold on. This is not my fault. This is the fault that this is my fault. Actually, this is completely my fault. I updated OBS right before I started streaming, and the little volume levelers are sitting in different orientations. Used to, it was the little slider was on the bottom. Now it's on top. I'm just going crazy over here. Ladies and gentlemen, thank you so very much for hanging out with me. I'm your Lone Wolf Weasel, and I have been having audio problems for the last minute and a half. And chat has been amazing tonight. I've been freaked out about all these people with these crazy attitudes. And now I have my microphone working. Yay! And I can say good night, everybody. Thank you so very much for hanging out with me. We do this every single night of the week. That means we'll be doing it again tomorrow night and the next night and the next night. Same Wolf time, same Wolf channel. That's 8 p.m. Central Time, 9 p.m. Eastern. And wow, I think I'm out of breath. It really wasn't that exciting. But look, if you're a gun carrying person in the state of Washington, just remember, there's a lot of people clutching pearls out there, and well, exercise your rights. Don't become a statistic. Ladies and gentlemen, have a great night. We'll see you next time. So, what do you think? What should we do tonight? I mean, this is just a little callback to Ferris Bueller's Day Off. But I want to impart just a little bit of wisdom while doing such. So just remember, most people work just hard enough not to get fired and get paid just enough not to quit. Have a great night, ladies and gentlemen.